know I got the receipts, girl. You know I got the receipts. Hey guys, what? Ooh, sorry. Hey guys, welcome back to the Sweet Pea Diaries. It's your girl, Sweet Pea, and I'm back with another video. If you are a returning subscriber, welcome back to my channel. And if you are a new subscriber, welcome to the Sweet Pea Diaries. Be sure to like this video, share the video, but most importantly, be sure to subscribe to the channel. Y'all know what time it is. All right, can you guys hear me? Let me know if you can hear who we got in the building. We got Saki, Speakeasy. Hey, Saki. We got Courtney Jackson, Letitia White, the real Virgo Queen, Coach White. You guys let me know if you can hear me, because we got some things to get into. So, Orbo Sexy. Hey, y'all. Y'all know, listen, this paperwork was entered in at 11:28 p.m. It just is hot off the press. And I know Tasha K and them, they like, this goddamn Sweet Pea, she does not sleep. She be on our ass. Anytime there's paperwork, she on it. What she got a goddamn? What she got an alarm set every 10 minutes? Wake up and look at Pacer. Ciao. Before we get into it, we got a sponsor that we would like to thank for tonight's video. I want to give a huge shout out and thank you to ExpressVPN, friend of the channel and protector of my online data. They are giving away 3 months free on a 1-year package to all Sweet Pea Diaries viewers by using the link in the description box below. Now, this is a service that I personally use 100% of the time when I'm on the internet using my phone or computer. It allows me to bypass content restrictions while traveling and ensures all of my data is 100% private and safe wherever I connect to the internet. Using ExpressVPN also allows you to get discounts when using services like Expedia, NBA League Pass, and Netflix. ExpressVPN also has 24/7 customer support to answer any questions and support all of your needs. So take back your internet privacy today by clicking on the link in the description box below and find out how you can get 3 months free. And their link is in the description box below. The real Virgo Queen said, run that tea, boo. I know that's right. We gonna run it too. Gotcha, let's go. Let's go to the plane. Mommy, daddy, let's go. We going to the Dominican. Come on, gotcha, get your Birkin bags. Let's go, mommy and daddy. Y'all, my allergies is really kicking me in my behind, so my throat is a little agitated, so please just excuse it. I got a little hoarse voice, but we gonna get through it. Now, disclaimer, we are not attorneys, we're not legal professionals, we're not paralegals, none of that. We ain't go to law school. Hashtag we can read in the chat. Go ahead and put our hashtag we can read. We break it down in layman's terms, you know what I'm saying, common sense. and we go over these court documents. This is what we do. Thank you. She says, you really are good at what you do. I appreciate you, Keisha. Hey, Vanderveer, my moderator. Hey, girlfriend. So, y'all, I was sitting here and I actually was doing an update on the Texas shooting, the school shooting that happened in over there with the, Uvalde, Texas, I think it is. And I was doing that. And I said, well, let me go ahead and take a look and see if there's been any updates with the case. Lo and behold, bam! Tasha K and her attorneys have submitted their appeal brief. Now, we still do not have a response from the court whether or not jurisdiction, if they've determined that they have jurisdiction, if they've determined citizenship or any of that, those three questions. We still don't have a response from the court about that. So Tasha K and her attorney, I guess, they just still going forward because they had a deadline to meet. They had to turn their brief in by a certain time. So they went on ahead and did that. So that way it's not, considered late or expired or whatever, even though they have not heard from the court about those questions. They went on ahead and just still went through with what they're supposed to be turning in. So we know that Tasha and her attorneys, that they had an appeal and they had specific reasons for their appeal. Now, here's what their reasons were. All right. So they already had reasonings, for what they wanted to appeal this for. So let me get this stuff right. Okay. And I have to put this in front because I'm going to put this in front because this is my paperwork. And I'm going to just, let me put this down a little bit. I didn't have time to put my logo on it or anything like that. So I'm just going to do it like this. And I'm just going to read it to you guys. All right. So this was their little form here. And let me fix this. Do it like this. I'll do it like that so you can see it. Okay. So they had their reasonings as to why they wanted to appeal it. So they said they were appealing it because the plaintiff did not meet the burden of proof for actual malice for public figure defamation. The court erred in forbidding the defendants from presenting character evidence of the plaintiff to combat defamation and invasion of privacy claims. The court erred in not using the defendant's proposed special verdict form and instead using a general verdict form, which makes it impossible to know what the jurors decided regarding each statement and each claim. There may be some other minor issues that are raised. So this was the three reasons that Olga and Tasha K, this is what they appealed for. All right. They said that Cardi B did not meet the burden of proof to prove that actual malice was committed. That when Tasha posted these videos and posted these defamatory statements, that actual malice was not proved during this case, that she did this in malice. She also said that the court erred in forbidding Tasha K from putting character evidence about Cardi B. So they said that to combat defamation and invasion of privacy claims, they should have been able to present character evidence about Cardi B. They were not able to do that. So they said the court made an error in doing that. They also said that the special verdict form that they wanted to use, the court did not use that form. Now, what the special verdict form would have just done, it would have showed, it would have been a form that listed what the jury decided regarding each statement about the claim. Okay, but they used a form and they did put what they decided for each statement. They just didn't use the form that they wanted them to use. They used the form that the court had. Okay, so those were the reasons that this appeal was brought forth. Okay, so now here is their official brief. Okay, because the rules and the way an appeal goes, when you issue the court your intent to appeal, that's what we just read. All right. Then the brief comes, and the brief is the actual formal, written out argument as to why this should be overturned and should be a new trial given. Okay, because when you do an appeal, in a sense, that's what this is. You're overturning, you would be asking the court to overturn the ruling and issue a new trial. So the statement regarding oral argument. Defendants, appellants, Tasha K and K Studios, LLC. All right, let me just make sure that we're on that you guys can see that. Yep, that's where we're at. Statement regarding oral argument. Defendants, appellants, Tasha K Studios, LLC, believe that oral argument in this matter is unnecessary because the facts and legal arguments are adequately presented in the briefs and record, and the decisional process would not be significantly aided by oral argument. Should oral argument be deemed appropriate, however, defendants, appellants do not waive their participation. So what they're saying is here is that we don't need an oral argument. We don't need to come before the court and orally give our statement as to why an appeal is needed. We can get our point across with this brief. We don't have to come before the court. But should it be deemed appropriate, we're not waiving our participation. We will show up and participate. That's what that means right there. So the table of contents, they've got it all laid out. And their argument is, 1, the evidence was not sufficient to support a verdict for the plaintiff. There was not a clear and convincing showing of actual malice to support a verdict for the plaintiff on the defamation claims. There was not a clear and convincing showing of actual malice to support a verdict for a plaintiff on the false light invasion of privacy claim. The evidence was insufficient to support a verdict for the plaintiff on the intentional infliction of emotional distress claim. The district court erroneously excluded evidence of plaintiff's character. The verdict was not entered upon a proper basis. Therefore, the verdict cannot stand. So this is 41 pages. So we're getting ready to get into it. All right. So if you guys... Again, this is a disclaimer. This is a reading of court documents. This is not going to be an outline or this is going to be long. I'm going to be reading it. So if this is not something you want to hear, please just, leave the video. Don't be saying rude stuff in the comments because I have to read this. Okay? All right. Y'all ready? Let's go. The statement of jurisdiction. The court had jurisdiction over the subject matter of this action based on diversity of citizenship pursuant to Rule 28 U.S.C. 1332. After a jury returned a verdict for the plaintiff, the district court entered final judgment on February 17, 2022. Defendants filed a timely notice of appeal on March 17, 2022. This court has jurisdiction of appeals from all final decisions of the district court pursuant to 28 U.S.C. 1291. The statement of the issues. Whether the evidence was sufficient to support a verdict for the plaintiff. Whether the district court committed evidentiary errors. Whether a general verdict for the plaintiff against the defendants was entered upon a proper basis. The statement of the case. The appellants were the defendants in the district court and collectively will be referred to as the defendants. Tasha K will be referred to as Ms. K and K Studios LLC will be referred to as K Studios. The appealee, Begalis Almazar, will be referred to as the plaintiff. All right. Course of proceedings. On March 21st, 2019, plaintiff filed a complaint in this action naming Ms. K and Star Marie as co-defendants. The complaint consisted of 4 counts. The first 3 counts alleged defamation and the 4th count alleged invasion of privacy. Ms. K timely filed her answer, raising truth and privilege as 2 of her affirmative defenses. Ms. K also filed a counterclaim for slander, punitive damages, and litigation expenses, which was dismissed. On June 12, 2019, the plaintiff filed her first amended complaint, adding 3 more counts alleging intentional infliction of emotional distress, punitive damages, and litigation expenses. Ms. K timely filed an answer, again raising truth and privilege as 2 of her affirmative defenses. Ms. K also amended her counterclaims, adding assault and intentional infliction of emotional distress. The parties filed a joint preliminary report and discovery plan on August 26, 2019. After several extensions from the district court, the discovery period was scheduled to end on November 29, 2020. On the last day of the discovery period, the plaintiff filed her second amended complaint, removing Star Marie Jones and adding K Studios as a co-defendant. On April 8, 2021, the district court heard oral argument from counsel regarding summary judgment and took the matter under advisement. On July 8, 2021, the district court entered an order granting summary judgment as to Ms. K counterclaims and denying summary judgment as to plaintiff's claims. On October 14, 2021, the parties filed a proposed pretrial order. Over the next month, the parties filed their motions in limine and their respective responses to said motions. The district court held a pretrial conference on November 9, 2021. Jury trial began on January 10, 2022. On January 24, 2022, the jury returned a general verdict for the plaintiff, finding the defendants jointly and severely liable for defamation, invasion of privacy, and intentional infliction of emotional distress, awarding the plaintiff $1 million for pain and suffering and reputational injury, $250,000 for medical expenses. The following day, the jury returned their second verdict for the plaintiff, finding the defendants liable for punitive damages, $1 million against Ms. K and $500,000 against K Studios, and $1,338,753.47 in litigation expenses. Due to serious concerns that the evidence did not support a $250,000 award for medical expenses, the parties stipulated without waiving any appellate rights to reduce the medical expense award to $25,000, and the district court entered its final judgment on February 17, 2022. Defendants filed a timely notice of appeal on March 17, 2022. The statement of facts. The plaintiff is a Grammy award-winning musical artist and songwriter professionally known as Cardi B. Miss Kibi is an entertainment and celebrity news blogger whose brand is Unwind with Tasha K. Miss Kibi is the owner, producer, and host of a YouTube channel called Unwind with Tasha K. Miss Kibi and her husband, Shek Kibi, are the only two members of Kibi Studios, and they each own 50% of its membership units. The controversy began in September of 2018 when Miss Kibi published a video on her YouTube channel in which Miss Kibi interviewed Jones regarding her past friendship with the plaintiff. Over the following 3 years, Miss Kibi and the plaintiff went back and forth with each other via their social media accounts, and Miss Kibi published several additional videos discussing the plaintiff. Since September of 2018, the plaintiff sent Miss Kibi 3 separate requests to remove certain videos and retract certain statements regarding the plaintiff. Miss Kibi did not remove any of the requested videos or issue any retractions or repudiations. The plaintiff sued the defendants for slander and libel, alleging that they defamed the plaintiff by publishing the following 6 statements. The plaintiff was a drug user. The plaintiff specifically used OA. The plaintiff has ease. The plaintiff has AEE. The plaintiff engaged in a debating act with a beer bottle, and the plaintiff committed infidelity. The plaintiff also sued for false light, invasion of privacy, based on the same 6 statements as her defamation claims, and intentional infliction of emotional distress. The plaintiff alleged that the defendants caused her embarrassment, humiliation, mental anguish, emotional distress, and impairment to her name, character, and reputation, for which the plaintiff sought general and special damages. The plaintiff also sought punitive damages and litigation expenses. The plaintiff is a public figure. At the trial, Ms. Kibi testified that the mission of Unwind with Tasha K is to investigate stories that sources bring to her or that are already on the internet and determine who those stories belong to and whether they are real or fake. Ms. Kibi explained that when she said it is okay to put out fake news, she meant that sometimes she will talk about a story on her YouTube channel specifically to inform her viewers that based on her investigation into that story, she's determined that the story is fake so that the viewers will not believe it. So let's rewind that. All right, we've been doing a lot of reading. So now let's take a break and let's rewind and unpack this. So her mission statement and her mission, she testified at trial under oath. She testified that her mission is to investigate stories that sources bring to her. They're already on the internet, and her job is to determine whether these stories are real or fake. She explained under oath or at the trial on the stand that when she said it's okay to put out fake news, she meant that sometimes she will talk about a story on her YouTube channel specifically just to let her viewers know that this is fake, guys. And based on my investigation, I've determined that it's fake and you should not believe it. Okay, so what we know, what really happens, Judge, is that they find the stories on Lipstick Alley and then they add bits and pieces to it to beef it up a little bit more and turn it into a story. Because we know that the little threads that be on Lipstick Alley, they just be little, gossip pieces, and then they put together a little bit more and add some shit onto it and beef it up and make it a story. That's what they really meant to say. That's what I really meant to say, Judge. I find shit on Lipstick Alley. I put a little bit of oomph on it. And then I make a story. That's what I meant to say. That's what she meant to say, okay? Now, as with most other stories that Miss Kibi discusses on her YouTube channel, she first heard about Jones when a video Jones published on her Instagram page detailing her relationship with the plaintiff went viral. Jones' story was super viral, and Miss Kibi, much like a lot of other entertainment bloggers, went after the story. Miss Kibi reached out to Jones, and Jones agreed to record an interview with Miss Kibi for Miss Kibi's YouTube channel. On September 19, 2018, Miss Kibi published a Jones interview on her YouTube channel, titling it Exclusive. Cardi B's ex-friend alleges that Cardi B kept a box filled with monostat and reveals more. The video of the Jones interview was admitted into evidence as Defendant's Exhibit 5 and published to the jury in its entirety. In the interview, Jones explained that she met the plaintiff in New York when Jones was working at a strip club there. The plaintiff asked Jones to get the plaintiff a job at the strip club, and in exchange, the plaintiff agreed to let Jones live in plaintiff's apartment with her. Throughout the interview, Jones detailed her experience as plaintiff's roommate and shared stories about what occurred inside the strip club while they were working, as well as things they did after work. Jones even shared a story about the night she met up with plaintiff and a man whom plaintiff invited because the plaintiff agreed to have sex with him for money. Jones recalled that plaintiff used drugs such as Molly and Oane, and that the plaintiff got cold sores on her lips. Jones used the terms herpes and cold sores interchangeably while talking about the plaintiff, so Ms. Kibi made sure to clarify that Jones was not referring to genital herpes when she used the term herpes. Jones confirmed that she was talking about the plaintiff's cold sores, which are one form of the herpes virus. Even during Ms. Kibi's cross-examination, when asked whether she knew that Jones said plaintiff had herpes, Ms. Kibi answered cold sores to be exact. The jury also watched a video Ms. Kibi published on her YouTube channel on December 18, 2018. In that video, Ms. Kibi projected the definition of cold sores onto the screen for the viewers, and that definition stated that cold sores are an infection with herpes simplex virus around the border of the lips. Once the plaintiff found out that Ms. Kibi interviewed Jones, plaintiff initially took to her social media and denied knowing Jones at all. But shortly thereafter, the plaintiff posted a video on her social media where the plaintiff admitted that she knew Jones. At trial, plaintiffs testified that she reached out to Ms. Kibi via social media to notify her that Jones was lying about living with the plaintiff. In response, Ms. Kibi offered the plaintiff the opportunity to come on Ms. Kibi's platform and tell the plaintiff's side of the story, but the plaintiff declined an interview with Ms. Kibi. However, the plaintiff did provide Ms. Kibi the names of some people who worked with the plaintiff and Jones during the period of time Jones discussed in her interview. Ms. Kibi honored plaintiff's request and had conversations with those people to see whether they could corroborate Jones' story. After Ms. Kibi had conversations with the former co-workers, Ms. Kibi released an update video on her YouTube channel on September 21, 2018. The title of the video was Actual Proof Cardi B Knew Her Ex-Roommate, Drake, Funky Dineva vs. Tamar, Beyonce, Black Magic, and Ms. Kibi explained that this video contained a variety of stories, so it wasn't just about the plaintiff. In the video, Ms. Kibi revealed that the plaintiff's former co-workers corroborated some of the statements that Jones made during her interview. Specifically, Ms. Kibi was able to confirm that the other co-workers did not like Jones and that the plaintiff was the only one of them who was nice to Jones and even defended Jones at the strip club. Additionally, Ms. Kibi confirmed that Jones was punched in the face by one of their co-workers and that the plaintiff did try to help Jones out while they were both working at the strip club. Throughout Ms. Kibi's cross-examination, opposing counsel relentlessly talked about supposed receipts that Lovely T had discredited Jones' story and made a huge deal about Miss Kebe not reviewing those receipts prior to publishing Jones's interview. Miss Kebe explained that Lovely T did not discuss her receipts with Miss Kebe because Lovely T wanted to make sure that her receipts weren't fake. In the proof video, Miss Kebe published Lovely T's screenshots and informed her viewers that these screenshots were indeed fake because they were photoshopped. Although Miss Kebe did not corroborate every single word from Jones's interview, based on her conversations with the co-workers, Miss Kebe concluded that Jones did live with the plaintiff and that they were close because the plaintiff wouldn't have bothered to defend Jones at the strip club otherwise. I didn't know that you don't have to be close with somebody to help them out in a fight. In addition to the information Miss Kebe obtained from plaintiff's co-workers, Miss Kebe testified that she has seen pictures of the plaintiff with cold sores on her lips. Miss Kebe has also seen pictures of the plaintiff's husband with cold sores on his lips. Furthermore, Miss Kebe knew about tons of tweets regarding the plaintiff having herpes or cold sores dating back to 2015. Miss Kebe also heard the viral diss track released by Jocelyn Hernandez, where she tells the plaintiff to worry about your herpy, bumpy mouth. Miss Kebe also knew that Azealia Banks, another celebrity, talked about the plaintiff having cold sores. Although those tweets, songs, and interviews are still available to the public, and Miss Kebe testified that the plaintiff has never sued Jocelyn Hernandez, Azealia Banks, or any other social media influencers for defamation. In fact, the plaintiff admitted on the stand that in May of 2018, Azealia Banks publicly called her a mediocre cold sore having bird, which sparked an online feud between plaintiff and Azealia Banks. Azealia Banks even appeared on The Breakfast Club to talk about the plaintiff's cold sores and their ongoing feud. The plaintiff also admitted that Azealia Banks' tweets, posts, and Breakfast Club interview are all still available online, yet the plaintiff confirmed that she's never sued Azealia Banks for defamation. And finally, Miss Kebe saw a video the plaintiff posted on social media, which Miss Kebe believed, based on her Google Translator search, was plaintiff's admission that she has cold sores. Although Miss Kebe did find out later that she was mistaken about what the plaintiff actually said in that video. So even though you know you were mistaken and you found out that you were mistaken, Olga still put that shit on this brief. The fact that I find it, okay, now I have to take a break right here and interject. Jocelyn did it. Azealia did it. They did it too. You're not suing them. That sounds like childish. It's just very childish. To point the finger at other people. That's like saying they jumped off the bridge. They jumped off the bridge. You didn't say anything about them jumping off the bridge. Like, just because you see something someone else is saying on the internet doesn't give you a right to say something on the internet. That doesn't mean that you have the right to put up videos and allege that someone has something. Now, even through all of this, even with this brief, you were found liable at this trial. You also were given medical documentation that showed that this woman does not have herpes. She doesn't have it. And you still are on here talking about these cold sores, alleged cold sores. Even after. This just shows how hard-headed this woman really is. And Olga is just like her. Even after proving that she doesn't medically have this. And for those that say that that's not, it is true. That is true. UCLA medical records prove that she doesn't have it. Oh, she can buy that. No. She cannot buy medical records from UCLA. She can't buy, I don't have herpes from UCLA. Even after proving she don't got it, they still throwing this shit in this brief. Ms. Kebe testified that when she said the plaintiff used to be a prostitute, she believed that to be true because Ms. Almazar has made various videos over the course of her career bragging about being a prostitute and having tricks. The plaintiff testified that when she was a stripper, before she was famous for her music, she became an internet sensation because of her posts on social media. A lot of plaintiff's content consisted of short videos of herself informing her followers about various topics of interest. The plaintiff admitted that she referred to herself as a stripper hoe in the videos she posted on social media. Of course, they were vines, jokes, and they proved that during testimony that these were vines and it was little clips that they put together and it was a joke. They were jokes. People say jokes and they put things in lyrics all the time. We have rappers now that they're trying to use lyrics, to in their cases in court, again, RICO cases and everything. And they're saying, oh, you can't use these lyrics, to indict them and stuff like that and to try them because they're just lyrics. People could say anything. So she could be saying she was, acting out certain skits in these vines. There was a couple times where she was actually dressed like this for Halloween and was, just making jokes about things. Oh, God. I mean, this is pathetic. I mean, even on the stand and even in trial, it came out that these were vines, and yet they still putting this stuff in the brief. Again, just something to have, something to turn in because they have to turn something in. Ms. Kebe was questioned about telling her viewers that plaintiff put a beer bottle in her vagina. Ms. Kebe testified she made that statement after she watched a video of a woman dancing on stage at a strip club, grabbing a beer bottle from a patron and put it up her vagina, take it out, and then give it back to the patron. Ms. Kebe explained that she believed the woman in the video was the plaintiff because she looked just like the plaintiff and because the video was titled Cardi B Puts Beer Bottle in Her Pee. The first time Ms. Kebe saw that video was on a website called Pornhub. Ms. Kebe has also seen that video on various popular porn websites. The plaintiff testified that when she found out about the existence of the beer bottle video, she got on Twitter and said that it wasn't her in the video. However, Ms. Kebe testified that the video is still available on all popular porn websites, where it continues to be monetized with the plaintiff's name in the title. Oh my God, I can't believe this. The plaintiff... So, Olga's saying that video is still on Pornhub and the people got Cardi B name on it. So, you going to try to say that's why you thought it was Cardi B because they put that it was Cardi B and it looked like it was Cardi B. And you knew that it wasn't her because even afterwards, everyone found out who it really was. You knew that it wasn't Cardi B. Even at trial, you admitted that you found out that it wasn't Cardi B. Plaintiff testified that besides the defendants and Jones, she's never sued anyone else for defamation. Ms. Kebe testified that when she said that the plaintiff put a beer bottle in her JJ, Ms. Kebe believed that to be a true statement based on the fact that the person in the video looks just like the plaintiff. You didn't know it was to be her or not. She just looked like her. So you went on ahead and said it was her because it looked like her. Whoo, child. The plaintiff's name is on the title of the video, which continues to be available on all popular porn websites. And the fact that the plaintiff has not taken any legal action against those porn websites who continue to monetize the video, to have the video removed, or at the very least to have her name removed from the title. How do you know what she has tried to do? You have no idea how long and how hard it is to get through to these porn sites, these, different people that make the video. It's hard to contact people that done made a video years ago. You don't even know the source of the video. How do you know if she hasn't tried to contact anyone about this? You don't know that. Ms. Keeby testified that the reason she called the plaintiff a drug user was because the plaintiff admitted in an interview with Rolling Stone magazine that she took Molly to boost her confidence when she stripped. And Jones mentioned in the interview that plaintiff did Molly and O'Ain. So Ms. Keeby testified that the plaintiff has videos where she bragged about popping, whatever she got to pop to make her feel good. She calls it a little something something. Additionally, back in 2018, Ms. Keeby read a long post from plaintiff's father-in-law's Facebook account in which he mentioned his son and plaintiff's drug use. Most importantly, the plaintiff admitted on the stand that she's used drugs such as Molly, Percocets, weed, and alcohol. Plaintiff denied using O'Ain. So the statement that Tasha K is being sued, she was sued for and found liable, was the O'Ain. It wasn't Molly, it wasn't Percocets, it wasn't weed. So just because someone has a previous history of entertaining drug use while they were stripping doesn't give you the right to go around saying that they use O'Ain. If they've never said that that is something that they've used, you can't say, well, she said she did Molly before, she said she did Percocets before, so then I'm going to say she did cocaine because she said she did these other things. That's not fair. You can't say that. Hold on 1 minute, guys. Okay. Yeah. So you can't say that because someone has admitted to using drugs or alcohol, Percocets or whatever, that you can just put any type of drug you want to put on them. That's just not, you can't do that. If you can't see, turn the light on. If you can't use that one. So throughout the entire trial, there was only one piece of evidence pertaining to the plaintiff having HPV. That evidence was a 29-second video clip in which Ms. Keeby mentions that the plaintiff has HPV and then immediately says, "Can I confirm it? I can't confirm the HPV diagnosis." After that video clip was played for the jury, Ms. Keeby testified that she never reported the plaintiff having HPV as a fact. Furthermore, Ms. Keeby testified that she never mentioned HPV anywhere else in that video, which is 1.5 hours long. Nor has Ms. Keeby ever mentioned anything about the plaintiff HPV in any other videos. That's a lie. That's a lie. She has mentioned on many occasions that Cardi B has HPV. She's mentioned that she has herpes. She's called her cold sore B. We all know that that's not true. She definitely has said and referred to HPV when it comes to Cardi B. All right, but it's the lies for me. It's now, trying to get out of this by lying. Okay, an appeal brief is not an opportunity to lie and to backtrack. But that's what they doing, child, in this brief. They just lied, pants on fire. In the same 29-second clip, Ms. Keeby said there are constant reports of the plaintiff's husband cheating on the plaintiff. So Ms. Keeby stated that she heard from an undisclosed source that the plaintiff was sleeping with someone other than her husband. The plaintiff testified that on December 5, 2018, she made an announcement to the media that she split from her husband. On January 31, 2019, the plaintiff announced their reconciliation. The plaintiff also admitted to making and publishing a video in which the plaintiff advised her followers that if a guy cheat on you, you should cheat on him back. Ms. Keeby testified that she did not build her YouTube channel for the purpose of harassing the plaintiff, that she is not engaged in a malicious campaign to defame the plaintiff, that she's never made up any stories about the plaintiff, and that Ms. Keeby's information about the plaintiff comes from the plaintiff's posts and videos for the most part. The plaintiff testified that she felt like Ms. Keeby's posts and videos were directed at the plaintiff. During cross-examination, while being questioned about one of her videos, Ms. Kebe was asked whether the video is supposed to be directed at the plaintiff, to which Ms. Kebe replied, "It's directed to my audience." Later on, while Ms. Kebe was being questioned about a different video, she's asked whether she's talking directly to the plaintiff, and Ms. Kebe again states that she's talking to her viewers. And we know that that is not true. Tasha K repeatedly calls out Cardi B and directly talks to Cardi B in these videos. She does not talk to the viewers when she's calling her herpes B, screaming, ranting, raving, cussing, going off. She's talking directly to Cardi B. When she offered Cardi B to a celebrity boxing match, she was talking to Cardi B. She was not talking to the viewers. But see, what's getting me about this brief as I'm reading it, it's almost like Olga is trying to, again, explain Tasha K's actions. That's not the purpose of an appeal and of an appeal brief. Your job is to prove the 3 statements that you said why you are appealing this, appealing the decision, appealing the verdict. Right here, all you are doing is explaining Tasha K's actions and breaking down what happened over the course of the 3 years. We already know what happened over the course of the 3 years, and she was found liable. All of this that you're saying, they still, from the testimony, evidence, everything that was brought forth, she was found liable. You outlining what happened in the case and what they don't care nothing about this. You coming back, but Judge, she did this, but Judge, none of that matters. You said that the special jury verdict form is what you wanted them to use. You said that they were not allowed to enter in evidence about Cardi B's character. And you said that the plaintiff did not meet the burden of proof to prove actual malice. So those are the 3 things that you are supposed to be proving. All of this outlining what took place over the 3 years, what does that have to prove and do with any of this? I'm lost. So on direct, the plaintiff testified that over the last 2 years since the Jones interview was published, the plaintiff experienced feelings of helplessness, fatigue, anxiety, deep depression, anger, weight loss, and felt extremely suicidal. The plaintiff also stated that in late October, going into November of 2018, she was having a mental freaking crisis. So her therapist, Dr. Sherry Blake, came to New York for the weekend. The plaintiff testified that from November of 2018 through January of 2022, she has had about 10 sessions, both virtually and in person, with Dr. Blake. The plaintiff also stated that she continues to experience anxiety. Despite that testimony, the plaintiff was only able to provide proof of these 3 sessions, all of which were for therapeutic coaching, not therapy. What therapeutic coaching and therapy is the same? I mean, if it's not the same, how are you to determine and you to judge what they did in their coaching or therapy sessions? How are you to determine that it was not therapy? Dr. Blake testified that she does a lot of marital therapy where she helps couples understand and resolve their problems and conflicts. Dr. Blake also testified that she offers therapeutic coaching, which is working with people toward being goal-oriented, trying to resolve issues where they may be stuck and trying to work through those. Dr. Blake explained that therapeutic coaching is different from therapy, and that therapy is working with emotional healing. Regarding her weekend trip to New York in November of 2018, Dr. Blake testified that the plaintiff was in a mental health crisis and not doing well, and that Dr. Blake was quite concerned. Despite that, Dr. Blake did not make a diagnosis or conduct any therapy sessions. In fact, Dr. Blake didn't even write a report about those sessions until October 26, 2020, almost 2 years after the fact. Dr. Blake titled that report Therapeutic Coaching Summary and noted in the first paragraph that sessions were conducted to determine barriers that may interfere with the plaintiff's achieving her career goals. Dr. Blake also noted that at the time the plaintiff was not suicidal, which Dr. Blake confirmed during her trial testimony. Dr. Blake testified on direct that on a scale of 1 to 10, with 10 being the worst, the plaintiff was at a 10 when Dr. Blake saw her in New York. However, Dr. Blake told her assistant, Jenny Lester, that her sessions with the plaintiff went great, and Dr. Blake felt that she turned a corner with the plaintiff about establishing and maintaining a stress plan. First of all, Dr. Blake and her assistant, Johnny Lester, they are not going to be discussing sessions about Cardi B. So, of course, she's going to tell her that they went great because she's not going to, that's patient doctor confidentiality. Like, you can't be telling the assistant about Cardi B's sessions. The only concern Dr. Blake seemed to have was that other people were joining the plaintiff and plaintiff's husband on their upcoming trip to the Dominican Republic because Dr. Blake was hoping for plaintiff and her husband to have some downtime on the trip. In February of 2019, just 2 months after their first session, the plaintiff discontinued Dr. Blake's services. The next time Dr. Blake saw plaintiff was in 2020. On direct, Dr. Blake testified that plaintiff's mental health status deteriorated. Dr. Blake also said at that point that plaintiff talked about having feelings of suicide and Dr. Blake was concerned, so she made a safety plan. Dr. Blake wrote a summary regarding her sessions with plaintiff in 2020. And again, Dr. Blake's summary was devoid of any mention about the plaintiff being suicidal or having any suicidal thoughts. Curiously, Dr. Blake's summary does not include a safety plan, nor does it even allude to the fact that a safety plan was needed or created. Dr. Blake testified that she had sessions with the plaintiff in 2021. However, no invoices or summaries from their 2021 session were provided or introduced at trial. They didn't ask for them. Nobody asked for, any of that to be provided. And she has, multiple business endeavors. She's got accountants. She's got people that are over her finances and doing, things. How do you know what books or where that invoice could be located? Cardi B is a really large celebrity and machine. She got a lot going on. So she don't have just one checkbook or just one book with all her dealings and what's going on in her financial situation. That could be anywhere. All right. And that wasn't required to be turned in. Again, no invoices or summaries from their 2022 sessions were provided or introduced at trial. Dr. Blake testified that the plaintiff has been invoiced for $10,000 worth of therapy sessions. Yet the plaintiff only introduced 3 invoices totaling $5,980.37. On cross-examination, the plaintiff was questioned about some of her personal and professional accomplishments since 2018, including winning a Grammy for Best Rap Album in 2019, winning Top Female Artist at Billboard Music Awards in 2019, purchasing her dream home in Atlanta in December of 2019, releasing a very successful hit called WAP with Meg Thee Stallion in August of 2020, becoming the first female rapper to be named Woman of the Year at the Billboard Women Music Awards in 2020, attending Fashion Week in Paris in October 2021, hosting the American Music Awards in November of 2021, and winning an award for her song Up, signing a deal with Warner Chappell Music, purchasing a home in New York, releasing a vodka whipped cream called Whip Shots, collaborating with Halle Berry on a soundtrack for her movie Bruised, becoming the first female rapper to have earned 3 diamond singles, being named the creative director for Playboy magazine, and gifting her husband $2 million for his birthday. The plaintiff had 120 million followers on Instagram and 20 million followers on Twitter. What the hell does that have to do? Oh does child, what does any of that have to do with my bill? What does any of Cardi B's accomplish? But see, that shit just tell me right there. They ran that accomplishment list down. Okay? Now, why would she be questioned about that on cross-examination? Why would Olga and them be cross-examining Cardi B and asking her about accomplishments? That just go to tell you that they know everything about Cardi B. They are really envious about her accomplishments and what she is doing in her career, because that don't got shit to do with defamation, invasion of privacy, her using OAIN, her cheating, all this shit that Tasha K said about her on the channel. That don't got shit to do with this at all. The standard of review. This court is required to examine the evidence with careful scrutiny when determining whether the evidence is sufficient to support the verdict. Although we are not in a position to judge the credibility of witnesses, our duty is to make an independent examination of the evidence and determine whether there was a clear and convincing showing of malice. This court reviews the district court's legal decision to apply a particular rule or evidence, but its decision to admit or exclude evidence under the rule for an abuse of discretion. We will not overturn any evidentiary ruling unless the moving party establishes a substantial prejudicial effect. In cases where jurisdiction exists based on diversity of citizenship, the state law controls as to any issue not governed by the Constitution or the treaties of the United States. Now, this brief, I'm going to bring this back for the viewers. This brief, we are here tonight because Olga and Tasha K stated that they needed an appeal because the plaintiff did not meet the burden of proof for actual malice. The court erred in forbidding the defendants from presenting character evidence about Cardi B. The court erred in not using the special verdict form for the jury. Those are the 3 points for this appeal. What the hell? We have read 26 pages of nothingness, and none of it correlates with the 3 points that are in this intention to appeal. None of it. You went down the line talking about Cardi B's accomplishments. You went through this brief outlining what happened in the 3 years with Cardi B and Tasha K's relationship. None of this has anything to do with the 3 reasons that you are appealing this case at all. Again, something to freaking turn in. Something that looks good. I'm going to put it together. I'm going to make it look like it's presentable and it's got a whole lot of legal jargon in it. It's a whole lot of nothing, because it doesn't support any of their claims that they erred in not using the special verdict form. I don't see how a special jury verdict form has anything to do with taking down videos, defamation, maliciously publishing videos. I don't see how a special jury verdict form has anything to do with the actual verdict. Nothing. It is a form, a piece of paper. You wanted to use that format instead of the format that the court used. But okay, you had to have something. All right. Then you say that they're not proving malice. That Tasha K, when she published these videos, that it was actually malicious. That they did not prove that. Cardi B and them, during the trial, they didn't prove it. I don't know how they didn't, because when Tasha got on the stand and was asked, so you're saying that the court is going to have to make you stop talking about Cardi B. They will have to basically issue a gag order. You told them yes. The judge actually said that your behavior and your personality, you came across as a person that would just do anything for clicks and views, that would do anything for videos to be watched by people, that you would say anything and he was surprised by your actions. So how is that not malicious intent? How is it that what you were doing, they didn't prove it? Even here, it's just like you're still trying to say that this girl got HPV, herpes, that she's got this on her mouth, that it was, you really thought it was her in that, put in the beer bottle when you knew it wasn't her. And then now you're pointing the finger. Well, Azalea Banks and them talked about her and she ain't suing them. That don't got nothing to do. We talking about you. We're not talking about Azalea Banks. We're not talking about nobody. We're talking about Tasha K. The deflecting. Why? This is not YouTube. This is pitiful. This is pitiful. So the summary of the argument. The plaintiff is a public figure who filed a complaint against the defendants for defamation, false light, invasion of privacy, and intentional infliction of emotional distress. The plaintiff sought to recover compensatory damages, punitive damages, and litigation expenses. During the jury trial, the defendants were prevented from presenting character evidence and specific incidences of conduct of the plaintiff, despite the fact that under Georgia law, if there is an assertion of damage to reputation, the plaintiff's character is substantively an issue. The jury heard a very lopsided presentation of evidence, and because they did not get to learn who the plaintiff truly is, the jury returned a general verdict for the plaintiff against both defendants. Okay, so what they're saying right here, they are saying that they did not get to present character evidence against Cardi B. And because they weren't able to do that, the jury got to only hear one side. They got to hear a very lopsided view of Cardi B. That's not true. What it was is there was evidence about, it was specific. See, now this again, for those that have been following this case and they have been with me since the beginning of this, what Tasha K's plan was, her plan was to try to make Cardi B look like a stripper, like a stripper, a person with no morals, this rapper that was gang connected, gang affiliated, that she just dressed provocative, have naked all across the screen, cussing, rowdy, and she didn't get to do that. She did not get to do that, and that's what she wanted to do. She wanted to use her YouTube tricks. She wanted to, do this presentation and have Cardi B be judged. And because she was not able to do that, this is what she's still trying to do. She wanted to present the evidence. She wanted to use as evidence the situation between the Watley sisters, what was going on with the court case in New York. She wanted to bring that. The judge told her during one of the hearings prior to their actual trial date, when they were, going through the motion in limines and different things where they were entering what they were going to have as evidence and present it, the court told them, no, you can't use that. It's irrelevant. And this is what Olga and Tasha do. You've been told no, and you still trying to get that shit in even after being told no. They wanted to try to make Cardi look bad. And because Cardi came across as looking like a woman, a mother, yes, she's a rapper, yes, she's a star, a mega star, yes, she has provocative lyrics, yes, it's adult content. Some of her videos and stuff and lyrics is adult content. But she still came across looking like a mother. She still came across looking like a woman. And that's what Tasha and Olga, they are upset about. They wanted to make this girl look bad and they could not. Because really, no matter what you do, she's going to come across looking like she is because she didn't do nothing to you. She didn't do nothing to deserve none of this. And that's what the jury was able to see. That's not nobody's fault but yours, Tasha K. Because everyone was able to see that she didn't deserve that treatment. No matter what you was doing and what you was saying about her, she didn't deserve that treatment. And that came across in the testimony. It came across when you were up there on the stand, when they played your videos and played your words, and everybody got to hear your loud ass rant, raves, and your bullying campaign. Everyone got to hear it. And it was nothing you could do to fix that because it was all you. So no matter what you do, it's not going to help this case. So they're still, even now, trying to get them. Well, if you just look at this, it doesn't matter. It doesn't change your behavior at all. The plaintiff's case was based on 6 statements, which she alleged were defamatory. However, the plaintiff failed to prove with clear and convincing evidence that the defendants published any of the 6 statements with actual malice. The gist of the plaintiff's evidence consisted of her general denial that any of the statements were true. Meanwhile, the defendants presented evidence that proved that they did not act with actual malice. The plaintiff also failed to present evidence to show that the defendants directed any of the 6 statements at her, thereby preventing her from recovering from intentional infliction of emotional distress. So now what they are, oh my gosh, this is really terrible. They are now trying to end this appeal, say that all of the 6 statements that Tasha K made, they were not directed at Cardi B. They weren't actually directed at her. Well, who was they directed at? The title say Cardi B. You calling her Cardi B in the video. You calling her Herpes B. You're calling her husband's name, Offset. You saying Cardi B. So who was the shit directed at? Now it wasn't directed at her. Who was it directed at? Another Cardi B? There's somebody else named Cardi B? Nevertheless, the jury's general verdict found that both defendants liable for defamation, false light, invasion of privacy, and intentional infliction of emotional distress. Due to the fact that this court cannot determine whether the verdict was entered upon a proper basis, the verdict cannot stand. How can the verdict cannot stand? Additionally, this court cannot determine the underlying tort theory upon which the jury based its award for punitive damages, so it too must be reversed. This case should be remanded for a new trial with specific instructions that the defendant should be able to prevent evidence of the plaintiff's character. So here's their argument for why they should have a whole new trial. They need a whole new trial. Okay? Tasha K needs a whole new trial. So we already been at this shit for 3 years. They done already. So now they need a whole new trial. Now we need to go and get a whole new jury, more taxpayers' dollars. We need a whole new trial. Let me tell you something. This court's going to be like hell to the no. They are not going to give you a new trial to go over this shit all over again. Because of YouTube videos. You taking already 3 years of people's time. Now you want to add more years, more time. You want a whole new damn trial for defamation because you can't just let this shit go. Because you got found liable. You got to pay almost $4 million. You can't just let it go. You can't just accept that you did it. You did it. It's over and move on. You want a whole new trial. Because you didn't get to present evidence of Cardi B's character. Okay. The evidence was not sufficient to support a verdict for the plaintiff because there was not a clear and convincing showing of actual malice to support a verdict for the plaintiff on the defamation claims. To prevail in a defamation action as a public figure, the plaintiff must prove with clear and convincing evidence that the defendants acted with actual malice. The showing of malice may not be presumed. It is incumbent upon the plaintiff to establish either that the defendant in fact knew that the material was false or that it was published with reckless disregard of whether it was false or not. They already proved that during the trial. Tasha K already admitted that she knew it was false. We have it in writing in the transcript that she said, I knew it was fake, but I published it anyway. There are times where she has said this in relation to videos. So I don't understand why we need a whole new trial to go over something that you already said you did. Now you want a new trial so you can take it back and say that, no, you didn't say that. We need a whole new trial so that everything that I said and admitted on the stand, I can now come back and say that, no, I didn't say that. So now when I'm asked those questions, again, I can now lie and say no. So I need a do-over. It is not sufficient to measure reckless disregard by a reasonable person's standard. The evidence must show in a clear and convincing manner that a defendant, in fact, entertained serious doubts as to the truth of his statements. This is not a proposition that can be supported by a normative conclusion that the publisher should have known of the falsity of the statement. In the case at bar, plaintiff's defamation claims are based on the following 6 statements: that the plaintiff was a prostitute, that the plaintiff was a drug user, specifically okay, the plaintiff has herpes, the plaintiff has HIV, the plaintiff engaged in a debasing act with a beer bottle, and the plaintiff committed infidelity. At trial, the plaintiff testified that all 6 statements were false, but that is not nearly enough to satisfy her high burden of proof. The statement may be false, but it is still not actionable unless it was made by the publisher in reckless disregard for the truth. At trial, the plaintiff spent a significant amount of time questioning Ms. Kebe about the fact that over the course of 3 years, Ms. Kebe received 3 demands to retract those 6 statements and didn't retract them. However, it has long been established that failure to retract or correct a falsehood does not prove actual malice. All right, so let's stop right here. If at trial, Ms. Kebe was asked several times, why over the course of the 3 years did she not retract her statements or remove after she was given 3 demands to retract them? So where is the accountability for those actions? If you were asked to remove the content and retract and you did not, where's the accountability? How is that's not proving actual malice? Why couldn't it just be done? What was the harm in taking it down? Ms. Kebe was questioned about her personal dislike for the plaintiff, which also does not prove actual malice. In fact, it is impermissible to use a defendant's hatred, spite, ill will, or desire to injure as evidence of actual malice. So it's that deep. Tasha K has hatred, spite, ill will. So Olga is even admitting that Tasha K has hatred, spite, ill will against Cardi B. Even failure to investigate does not in itself establish bad faith, especially given that Jones's story was super viral and Miss Kibi, much like a lot of other entertainment bloggers, went after the story. The test of actual malice is not whether the defendant acted as a reasonable publisher would have acted under the circumstances. Rather, the inquiry focuses on the defendant's state of mind at the time of the publication. When Miss Kibi published her interview with Jones, Miss Kibi believed that Jones was telling the truth about the plaintiff being a prostitute. Furthermore, Miss Kibi testified that when she said the plaintiff was a prostitute, she believed that to be a true statement because Miss Almazar has made various videos over the course of her career bragging about being a prostitute and having tricks. First of all, Tasha K knew damn well that she was not a prostitute. She knew that Cardi B had been a stripper. Okay. So to say that you believe that she was one of those because you believed that what someone was saying, so that gave you the right to make a video and say that these things are true because you believed a story from a third party. You believe that Jones was telling the truth. So that's why you went and made those statements. Miss Kibi testified that the reason she believed that the plaintiff used drugs is because Miss Kibi has seen plaintiff's videos where she talks about using drugs. Now, you specifically are not being called to the carpet about drugs. You're being called to the carpet about the C drug. Okay, that's what you're being called to the carpet for. So you can't put it all in one envelope and wrap it all in a bow because that's not what you're being called to the carpet for. You said this girl used cocaine and that she uses that. So you can't get around that by saying, well, I believed it was cocaine because she said she used drugs. So no, you can't just pull out a drug and decide to use that one as your go-to drug because you feel like she said this before. So then I can say, well, that's why I said she used cocaine. Like, no, you can't. Sorry. And all of this, again, has been proven at trial. All of this, we went over this under oath. The judge has already discussed this. So I don't understand why this is even in the brief. Why are we talking about any of this? This has already been determined that these things are not true. Why are they being presented in this brief as though they are? That's what's the question for me. Olga is presenting this stuff as though it is true. We have to remember, guys, that this stuff has already been determined that it is not true, that it is all lies. And yet she's presented it in this brief as though this is something that was proven as true. Child. Most importantly, the plaintiff admitted on the stand that she's used drugs such as Molly, Percocets, weed, and alcohol. But she didn't say she used cocaine. As the district court pointed out at the pretrial conference, it is disingenuous to argue that using Molly and using cocaine is any different as it relates to defamation and the harm that it would occur. Ms. Kibi has never stated that the plaintiff has genital herpes. When asked whether Jones said plaintiff had herpes, Ms. Kibi clarified cold sores to be exact. Ms. Kibi testified that when she said the plaintiff has herpes or cold sores, she is basing that statement on the following information. The definition of cold sores as an infection with the herpes simplex virus around the border of the lips. Pictures of the plaintiff with cold sores on her lips. Pictures of the plaintiff's husband with cold sores on his lips. Tons of tweets dating back to 2015, stating that the plaintiff has herpes or cold sores. Now, when I say pictures of plaintiff with cold sores around her lips, it has D3. So I'm assuming that D3 is a picture that they're trying to show that she had that. Then they have D8 about Offset. They're trying to say that he has it D6, D8. And then tons of tweets dating back to 2015 where she says she has cold sores or herpes. Hearing other celebrities say that the plaintiff has cold sores or herpes, knowing that those pictures, tweets, and statements are still available to the public and that the plaintiff has never sued any of those people for defamation, and seeing a video in which Ms. Kebe believes she heard the plaintiff say she has cold sores. Ms. Kebe has never stated that the plaintiff has HPV as a fact. A defamation action will lie only for a statement of fact. Ms. Kebe testified that when she said the plaintiff put a beer bottle in her vajayjay, she believed that to be a true statement because the person in the video looked just like the plaintiff. The plaintiff's name is on the title of the video. The video is still available on all popular porn websites, and the plaintiff has not taken any legal action against those porn websites. Lastly, while discussing yet another report of plaintiff husband's infidelity, Ms. Kebe mentioned that she heard the plaintiff was sleeping with someone other than her husband. She says she heard this. So she didn't know it to be true. She heard it. So again, I make a video and I say that Cardi B is cheating on her husband because I heard this somewhere. I don't got proof, and that means I can just say what I want based off no proof. There's no evidence that any of Ms. Kebe's stories about the plaintiff were fabricated by Ms. Kebe, or that they were a product of Ms. Kebe's imagination. They were based wholly on an unverified anonymous call, or were so inherently improbable that only a reckless person would have put them in circulation. She said there's no evidence of any of this. Negligence is constitutionally insufficient to show the recklessness that is required for a finding of actual malice. Given that the plaintiff failed to establish in a clear and convincing manner that Ms. Kebe knew her statements about the plaintiff were false or in fact entertained serious doubts as to the truth of her statements, the plaintiff cannot prevail on her defamation claims. B, there was not a clear and convincing showing of actual malice to support a verdict for the plaintiff on the false light invasion of privacy claim. A single statement cannot form the basis of both a defamation claim and a false light claim. To survive a separate action, a false light claim must allege a non-defamatory statement. If the statements alleged are defamatory, the claim would be for defamation only, not false light invasion of privacy. The plaintiff's false light claim alleges the same 6 statements as her defamation claims. Therefore, the plaintiff's false light claim cannot survive as a separate action. Now, if it could not survive as a separate action, it would have not been set up that way during the trial. The court would have not allowed for it to be set up that way. Even if the plaintiff could use the same statements as the basis for both claims to prevail on a false light invasion of privacy claim, the plaintiff must prove 3 essential elements, one of which is that the defendants acted with actual malice when publishing the statements. Adopting the argument from Section 1A above, because the plaintiff failed to establish in a clear and convincing manner that Ms. Kebe knew her statements about the plaintiff were false or in fact entertained serious doubts as to the truth of her statements, plaintiff cannot prevail on her false light claim. C, the evidence was insufficient to support a verdict for the plaintiff on the intentional infliction of emotional distress claim. In the absence of any physical impact to her person, a plaintiff seeking to recover for emotional distress must show, in addition to the 4 elements, that the conduct in question was directed at her. Defamatory remarks made to others or to the public in general are classic examples of conduct that, though harmful to the plaintiff, was directed toward the hearer of the statements, not at the plaintiff, and thus is not actionable as intentional infliction of emotional distress. So here what the liars are trying to do, Olga and Kebe, they are stating that these statements were not directly made to Cardi B. They were made to people that were listening to the video, the hearers of the video, people that heard the content. It was not directed towards Cardi B. So, we just had Cardi B in the title. We were just saying, a person that looked like Cardi B, sounded like Cardi B. But we weren't talking directly to Cardi B. It is undisputed that the comments here were made during video streams on Miss Kibi's YouTube channel to thousands of people. Furthermore, Miss Kibi testified that in those video streams, she is talking to her viewers, not the plaintiff. See, now this is the shit that the court is going to see, that you're trying to wiggle your way around. This is not like real errors of the court made errors. This is them trying to worm and wiggle and lie their way out of this verdict. So now you want to come back and say that you were not talking to Cardi B. You were talking to your viewers. So you were calling your viewers herpes B. You were calling your viewers simplex B. You were saying that your viewers put a beer bottle up their You weren't talking to Cardi B. Even if the plaintiff could somehow prove that the conduct in question was directed at her, the plaintiff must also show that Ms. Kibi's conduct was intentional or reckless, extreme and outrageous. There was a causal connection between the wrongful conduct and emotional distress, and the emotional distress was severe. So they got to now prove. Tasha got to now is saying that Cardi got to prove that Tasha was talking directly to Cardi B, and that it was reckless, it was outrageous, and extreme. Well, what else was it? What else was it? How was it not reckless? How was it not extreme? And how was it not outrageous? It has not been enough that a defendant has acted with an intent which is tortious or even criminal, or that the defendant has intended to inflict emotional distress, or even that the defendant's conduct has been characterized by malice or a degree of aggravation that would entitle a plaintiff to punitive damages for another tort. Conduct that can be characterized as merely vulgar, tasteless, rude, or insulting will not support a claim for intentional infliction of emotional distress. So they're saying that even though it is vulgar, it is tasteless, it is rude, it does not support a claim for intentional infliction of emotional distress. Even though she's already been found liable for these things, they have already been awarded money, they are saying that it was all an error. Olga's saying everything that the jury and the courts determined, it was all an error and it all needs to be overturned. Emotional distress includes all highly unpleasant mental reactions such as fright, horror, grief, shame, humiliation, embarrassment, anger, chagrin, disappointment, worry, and nausea. The law intervenes only where the distress inflicted is so severe that no reasonable person could be expected to endure it. And no reasonable person can be expected to endure that bullying and harassing and lies. All of the people in the comments now coming over and saying you got herpes, that was you with the beer bottle. All of the winos and people that watch Tasha K's videos. No reasonable person can endure any of that, let alone, the therapist, the doctor got up there and testified that Cardi B was in such an emotional distress. So we just going to say, forget all of that testimony. She wasn't, her saying that she wanted to commit suicide or commit self-harm or she felt suicidal. None of that is true. We just need to overturn everything and start all over. Miss Kibi is an entertainment and celebrity news blogger who discusses current stories about celebrities on her YouTube channel. Plaintiff's complaint centers around the fact that in some of the video Miss Kibi publishes, she sometimes talks about the plaintiff. Georgia's definition of outrageous conduct provides a high degree of tolerance for a wide variety of questionable conduct, and Miss Kibi's actions simply do not rise to the level of outrageousness required. The plaintiff cannot show the 4 elements required to recover. Therefore, the plaintiff cannot prevail on her intentional infliction of emotional distress claim. The district court erroneously excluded evidence of the plaintiff's character. Georgia law confirms that an assertion of damage to reputation in a defamation case makes the plaintiff's character an issue under the law. Plaintiff alleged that the defendants caused her embarrassment, humiliation, mental anguish, emotional distress, and impairment to her name, character, and reputation, for which the plaintiff sought general and special damages. Since the plaintiff's character is at issue in a libel case under Georgia law, Rule 405B permits the admission of evidence regarding specific instances of the plaintiff's conduct on that issue. The district court excluded a myriad of relevant character evidence both at the pretrial conference and during the trial. Exactly. During the pretrial conference, the judge said, no, we are not going to allow any evidence that, you're trying to enter in that would show anything about her character with these previous court cases, these allegations of her being a gang member. The court said no. And here yet, we're right back here again after being told no. We still here where they want to bring in this new evidence. And you can't bring in, with an appeal, you can't bring in new evidence. You have to use what you already have. You have to have your appeal surrounded around what you have in this case. Errors made, you cannot have new evidence that you want to enter in. And anything that would be relevant to a character evidence would be new because they already told you no. The district court excluded a myriad of relevant character evidence, both at the pretrial conference and during the trial. Specifically, the district court excluded all the evidence listed in Exhibit A of the plaintiff's motion in limine. The defendants described that the evidence was relevant to show the plaintiff's character. In the middle of the trial, the district court heard additional argument from the defendants regarding their desire to introduce evidence of the plaintiff's character. The defendants believe that they have shown a substantial prejudicial effect because even the district court stated that the plaintiff that testified on the stand is not certainly the plaintiff in the videos, not the same person in the videos that I've seen so far. The defendant should have been able to present evidence of the plaintiff's character as well as specific instances of the plaintiff's conduct. So, right here, even it says the defendants believe, it says, because even the district court stated, the plaintiff that testified on the stand is certainly not the plaintiff in the videos, not the same person in the videos that I've seen so far. Because you're confusing a person that plays a character in videos to a person that's on the stand. So you're saying Olga is saying that we need to be able to show this evidence that's going to show who she really is. Okay, so you want to introduce a character. You don't want to see the real Cardi B, which is what everyone saw. They saw the human, the mother, the woman. You wanted the character to be shown because the character is the one that is the gang member. She's cussing, she's vulgar, she's, exposed. Her body is, she looking good. Everything is out. The titties is out, the ass is out. You wanted her to look like this, and you didn't want her to come across as this human being that they saw on the stand. So the verdict was not entered upon a proper basis. Therefore, the verdict cannot stand. The jury returned a general verdict for the plaintiff, finding the defendants liable for defamation, false light, invasion of privacy, and intentional infliction of emotional distress. There were 6 separate statements, any one of which could have been the reason the jury found the defendants liable for defamation and for false light, invasion of privacy. However, the law provides that a single statement cannot form the basis of both defamation claim and a false light claim. The jury also returned an award of punitive damages for the plaintiff against both defendants. Given that the jury returned a general verdict and considering the argument presented in Section 1 above, the jury verdict cannot stand for the reason that this court cannot determine whether the verdict was entered upon a proper basis. That is all mumble jumble. That shit don't make no sense right there. Additionally, this court cannot determine the underlying tort theory upon which the jury based its award for punitive damages. So the punitive damages must also be reversed. That's bullshit. Now, conclusion: for the foregoing reasons, this court should reverse the judgment entered on February 17th, 2022 and remand the case for a new trial. Okay? Not only are we going to reverse it, we want a new trial as well. So, Vanderveer says Tasha requested Cardi fight her on video 2 times and she mocked Cardi, saying Nicki would have sent goons. Exactly. Tasha K tweeted she inboxed Herpes B to help her in her criminal case because the bartenders lied. So she was definitely talking to Cardi. She directly inboxed her. Okay? Like, girl, stop. Now, to sum this up, they turned in a brief, okay? We read it. It's 41 pages. They turned in a brief, and basically, one second, guys. Let me get this. Let me fix this. All right. So they turn in a brief, and basically what they are saying is that Cardi B, she did not meet her, the elements. What she sued for, intentional infliction of emotional distress, the defamation, putting the beer bottle, all these things. They're saying that we need a brand new trial because we did not get to present this woman's character. You didn't get to really see who we really wanted you to see. We wanted you to see this thug, this woman, that character that she plays on her videos. We wanted you to see that. We did not want you to see a human being that was bullied, ridiculed, made fun of. We didn't want you to see the truth. That's what came across on that stand, because when they played the evidence that they would use when they played Tasha K's videos, and you got to hear her mocking Cardi, you got to hear her bullying, ridiculing, dragging, you got to hear the vulgar, and you got to hear the disdain in her tone and in her voice for Cardi B, that put the nail in her own coffin. The jury heard it. The judge heard it. Everyone saw that it was unnecessary and it went too far. Everyone's question was and has always been, why didn't you just take the videos down? What was so great that you had to keep it up? You wanted the money that bad. Why didn't you just take it down? If somebody asked me to take videos down, I would have just took the shit down. The judge saw through Tasha K and saw that all she wanted was clicks, views, money, and that she was greedy. He said she was greedy. He saw that her attorneys were inexperienced. Olga was rude on a few occasions. She had to be told about herself on a few occasions. So all of this didn't look too good for Tasha K. It just didn't go well. It didn't go the way she wanted it to. So now they want a do-over because they want to be able to, they see what they did wrong, right? They've now looked at their case. They've now read everything, all the transcripts, everything, and now they want a chance to do it over. This is not YouTube. This is not a YouTube video. This is not a retake. You can't edit and get it and do it over and edit it to curtail the way you want it to look. This is not YouTube. This is real life. So unfortunately, you don't get to go look at the script, change some shit, come back, and now do it over. That's just not how life works. And that's not how a court of law works. And that's essentially what they want to do. Because now in the brief, you saying you wasn't talking to Cardi B. You was talking to somebody else. You was talking to the viewers. You was talking to the people that would watch the video. You were not talking to Cardi B. If she took it that way, that's on her. Because I wasn't talking to her. I was talking to the viewers. And to anybody that might hear or see the video. That just don't make no sense. But see, what is going to happen, like I predict, the court is not going to hear this appeal. It's not going to be overturned. It is going to be upheld. I do not see them going forward with this appeal. This brief in itself is just a whole do-over, asking for a do-over. They are still trying to insinuate that this woman has HPV, herpes, all of the things that have been proven at trial to not be true. They are still trying to come with this that she has it. Even after having medical documentation that proves she don't. They still talking about the cold sores and why she's saying, still trying to plead your case. This is not the time for that. That's already been done in cross-examination and questioning. All of that was done at trial. You are here for those three elements. You said that she did not prove actual malice, the special jury verdict form. You are not here to argue the case and to argue whether this woman got herpes or not. We already proved that she didn't. How many times what is it that she got to do? What is it that has to be done? So, I do not believe that, this case will be overturned. I don't believe that they will even hear this appeal. Of course, she's got to try. This is a last-ditch effort to try. She's got to try to get out of paying $4 million. And even now, even during this moment, Cardi B could actually collect on the judgment. She could start collecting on it if she wanted to. She could actually start, so that's where we are at with this. So now the next stage is Cardi B. They will respond to this brief, okay? They will respond and they will enter it in on the docket, and then the court will make its decision on whether or not they're going to hear this appeal, whether it's going to be. But we're still waiting on the court, whether they're going to dismiss this entirely. We are still waiting on the response of whether or not jurisdiction or citizenship, all of that has been proven. The court had questions as to whether they even had jurisdiction over this. They also wanted citizenship to be proven for Kiwi Studios. That still has yet to be ruled on by the court. We still haven't heard from that. So there are still updates that we're waiting on and we'll be looking out for. But the next batter up in this is Cardi B. We'll be waiting for her team to enter in the answer and response to this brief. All right? So that's it, y'all. Y'all hung with me. I know that was a lot. It was 41 pages of reading. It's 2:30 in the morning. So I will keep an eye out. And as soon as I know more, as soon as we have Cardi B's response, we'll be right up here to give you that news. All right. So this has been another edition of the Sweet Pea Diaries. You guys have a good night. Y'all get some rest, and I will talk to you tomorrow. Like, share, and subscribe. And make sure you go on over there and check out ExpressVPN and tell them Sweet Pea sent you. I want to give a huge shout out and thank you to ExpressVPN, friend of the channel and protector of my online data. They are giving away 3 months free on a 1-year package to all Sweet Pea Diaries viewers by using the link in the description box below. Now, this is a service that I personally use 100% of the time when I'm on the internet using my phone or computer. It allows me to bypass content restrictions while traveling and ensures all of my data is 100% private and safe wherever I connect to the internet. Using ExpressVPN also allows you to get discounts when using services like Expedia, NBA League Pass, and Netflix. ExpressVPN also has 24/7 customer support to answer any questions and support all of your needs. So take back your internet privacy today by clicking on the link in the description box below and find out how you can get 3 months free.